maybe some general questions, some general remarks or some general comments that I will do to give some context to the piece that I shared. Maybe some biographical notes will be also useful. I was trained as a lawyer in Peru. Later, I worked as a real estate lawyer, and that's how I got engaged in city, urban planning topics, and that's what I did my master here at Harvard some time ago. And now I'm coming to do a more historical type of work on the same topic, on cities, on the city of Lima, on cities in Peru or in Latin America, but now from a more archival type of methodology. And that's where this comes from. And this is part of what I want to start working in my dissertation, perhaps, now that I'm doing a PhD in history, so in urban history. So maybe that's helpful to give a context of what I am up to. That was first. Second is that probably the article has very specific details on the city, some neighborhoods, some people, and that might be maybe something that not many of you or maybe none of you are familiar with. But the objective is for the article to be published probably in a American journal or American review, perhaps in urban history. So it's going to be very useful for me to receive what are your maybe most unknown aspects of the article, or what could be maybe more important to develop more thinking in that audience. So the audience is going to be probably people that are not familiar also with the context, with the region. So that's, I think, useful to have that aspect here in the session. And finally, on the topic, maybe just a couple of things. One is that this comes from a paper that I started developing last year during the coursework stage of the PhD. And it comes from engagement with, maybe I will say, two things. One, with starting to do some archival work in this case with this archive of the association that I found, which is what I engaged mostly in the article, but also with this scholarship of the regimes of normativities scholarship that people have started to develop, especially in the Max Planck Institute for Legal History in Germany, which is basically the idea of using the concept of legal pluralism that is often used in studying the systems of law of maybe native communities, peasant communities outside the urban areas, but using that inside an urban space where maybe there are systems of law at play that maybe they are engaging between each other, they are interacting between each other, but you can maybe identify some differences in how people understand their system of law that might be, and that's what I say in the article, only slightly shifted from the traditional or from the official system of law in a city. That's what I want to. That's what I try to play with, thinking in the Peruvian civil code in property law, and how there are some things that are a little shifted from that in the legal practice of these neighborhoods or of these people. So that's maybe to give a context of where this is coming from. And I think that's it. And I will be happy to also clarify some details and some facts on some things that are maybe missing there, or some things that are maybe important for you to understand some of the more contextual aspects of the article. And again, thank you for making time to read it, and to Dennis for organizing this nice space. And that's it. Yeah.
Thank you, Jose, for that introduction. For those who don't know me, I'm Ángeles Picone, and I teach Latin American history here at BC. Jose, I appreciated your previous question to Dennis about legal history, because when Dennis invited me to comment on your paper, I was like, I'm not a legal historian. But then when I read it, it was like, oh, I guess I am a legal historian. And so the question was very apt because it's true. Like I used legal sources in my research, even though I don't engage with legal history more formally. So I appreciated that take on legal history both as a subfield, but also maybe as a way for us historians to engage with the historical questions that we're trying to answer. And I certainly appreciate this contextualization of your research, because I was aware that you didn't come from history, so I was wondering how much I could engage as a historian with your work. So I really hope that my comments and my questions are useful to you and make this paper stronger for publication. So I wrote a mini summary to see, because I've always found it helpful when people, vomited back at me what they understood of the paper as a starting point for the discussion. So this is a paper that focuses on the emergence of a barriada, or informal neighborhood, right? So a barriada would be an informal neighborhood, and in the northern outskirts of Lima in the late 1950s. And it focuses on an association, El Señor de los Milagros, that managed the barriada not only in terms of its relationship with the state, but also as a means to create a sense of community. So far, so good.
So far,
okay.
So good.
So I have like a bullet points of questions, and I don't have to read them all, and you don't have to take them all. To me, that means that your paper was thought-provoking. So I think that's a good thing. So I'm going to try to go from more general to more specific. I'm going to make that attempt. This is not in order of importance or any type of order. This is just me with a document open, just typing. One of the key aspects that I think would help you publish this, as you mentioned, in a journal that was not specific to the history of Peru, is historical context. I think that we would need to really understand why this specific neighborhood, in this specific city, in this specific country, is relevant to larger questions about the intersection of legal practices and normativity in Latin America more broadly. And to me, that's an unfair request, because in American journals or journals in the global north, people that do the US don't have to justify that much why New York, but we have to justify why Lima. And I think connected to this, one resource that can help you strengthen the argument and really situate it in a more regional context is mentioning what is happening in other cities across Latin America. Informal settlements is not new to Lima, and it's not new to Latin America in the early Cold War, to put a name to a chronology. I think that maybe looking at what's happening in Sao Paulo, in Buenos Aires, in Mexico City, just by mentioning it will really, really help you situate yourself within a conversation about urban history that will help the reader understand what you're doing here. So that's one of the big comments that I had, and maybe you can provide some of that historical context here. Speaking also about historical context and how there are multiple layers in this settlement that you could, like multiple threads that you could be pulling, and you don't need to pull all of them. But something that you mentioned is you drew this line between 19th century and then today, and then the 1850s. And so I was wondering why this particular moment in Peru is significant to understand urban change, if that is the ultimate question. But also how earlier practices of informal settlement inform this, the emergence of this barriada, especially as in colonial Latin America, neighborhoods were associated with associations, with cofradías. So there is a larger history that you could, be nodding to in your footnotes that could really strengthen your paper as a longer history of urban change, but also, as a specific moment in 20th century Peru. Okay, I think these are questions, because I wrote them as bullet points, but I think these are questions.
We'll find out exactly.
Yeah, so we will find out. Yeah. So, okay. So there's an interesting, you're doing urban history, right? But the settlements of the Association of El Señor de los Milagros takes place in what you describe as rural estates. So there's this, this fringe area between urban and rural, and I think that you could talk a little bit more about that. If these settlements were rural settlements, or if they were urban settlements, you kind of gave us the end of the story in your conclusion of how the buildings look like today, that there's public transportation, and this is, 2 or 3 story buildings. But at the time, was that the goal, or was it a more like rural type of settlement? You also, I think that one of the key concepts in the paper that need to be more clear for those of us who do not think we are legal historians, and speaking about the fear of theory, is sometimes to me it felt that you were using legality and illegality and formality and informality as the same things, and it made me wonder, is something that is can something that is informal be legal? And I can think of cases that it can, but I don't know if this is the case for the specifics of your project. And I think that with the historical context, that it will really help illustrate that what is the borders of legality, and how does legality and informality overlap, if they do. I am very curious about the title, Por Ser Justicia, because then you don't go back to it. So I wonder if you could talk a little bit about what would the Por Ser Justicia would mean. And it brings me to a question about something that you mentioned around the paper in the examples that you provide about formulas of how in these letters that the association sends to different people, to other actors. You mentioned, and this was a formula, like adiós guarde usted, or palabra de calle, like there was all these formulas. Yes. And to the very pragmatic historian and not very theoretical, that reads like, oh, that's really legal wording. So I was struck by that, more legal formula being used in a more informal normativity. That was my understanding of it. And I wonder if you could talk a little bit more about that, especially through the Por Ser Justicia, like why you chose that to condense your argument. I had a question about the state, which at the end you said, oh, this is a story about Lima. And it wasn't clear to me if this, so you talk about the district, and that's an English word that sometimes in Latin America we have to use to talk about a different type of legal jurisdiction that maybe there isn't a good English translation. So I was wondering if you could illustrate, so these neighborhood in Comas, based on the map that you gave us, it looked really far from Lima in terms of the jurisdiction, the territorial jurisdiction of the municipality. So, but then there was something at the end that got me confused, like, oh no, it was part of Lima. So when they are talking to the state, you know, they have letters to the president, to the first lady, to members of Congress, but are they part of the municipality? Or you kind of mentioned there's a mayor of the district, but that seems to change over time. So it seems to be more fluid than one would imagine, you know, like legal history. It seems to really static. I'm gonna stop there and allow other people to comment. I have more questions, but I think this is a good start, and maybe other people have, you know, more interesting things to say. But really, thank you for sharing your work with us.
No, thank you so much. Very, very interesting, very useful.
Do you want to offer some initial reactions, and then we can?
Yeah, or maybe I can, I can do it. So maybe I'll go in reverse order. So because I have more like a fresh what you mentioned at the end, and maybe not all of them, because some of them are, I think, totally on point, and I would like to work on this. But for example, in relation to the title, I feel that you have grasped what I was trying to play there with. Maybe I will maybe tweak it a little bit more. But por ser de justicia is one of these formulas that are used at the end of letters, at the end of writings.
Like an amen.
Yeah, like an amen. Like, and I think it is a good example of how certain formulas, certain actions, when we are talking about law, give some more legality to whatever you're doing. And that's why at some point I talk about ritual. It's a ritual at the end. It's a written ritual, I will say. And I chose that one because maybe that's the more common. And I think I mentioned at some point in the writing, but I think it is a fair question. Why that one? Why will that one be more important? Why not to use another one? Could be another one. I didn't want to use Dios guarde usted, for example, which has a religion connotation. That would be an interesting aspect that I don't engage that much in the paper, for example. So that's where that comes from. And I feel in what you said, that you related that with the formulas, and how that those legal formulas are being used in informal context. I think you captured what I wanted to convey there. Maybe I'll work better in the relationship between the text of the title and the text of the article, so it is more clear for everybody. But I think I'm happy that you made that connection, actually. Another one, I will just say that this distinction between legality, illegality, formality, and informality, and it's maybe the center of the piece and the article, and that's why I am trying to use this broader definition of law in terms of, even though we are classifying all this as informal, and maybe that will be the majority in some of the cities in Latin America, we think that word of informality, we can also find law, and that's why I'm using this concept of normativities, and that I think allows me to understand those dynamics in legal terms. So, and probably that's maybe, since it's the most important topic, the most important thing, maybe I have to maybe work a little better on that, so I can show how I'm using these concepts to study that world of legality inside the informality. So those two dichotomies that you mentioned, I think is what maybe I will have to flesh out a little better. So I think that's
and can I add
useful.
Something to that? Like that, what you call this broad definition of law, like, and different practices of what looks legal or not. Like, it's not new, right? But the way you
Yes.
worded it looked like, oh, I'm using this, like no one else is using it.
Right.
And so
yeah.
there's a historiography there in Latin America
Okay. Yeah.
that of course I don't have anything in my mind right now that needs to be acknowledged, of how this larger understanding of law can help us analyze informal settings, informal historical settings.
Yes, and actually, as you, that's related to one of the first things that you mentioned. Totally, that's being done. That's being explored at least in other cities in Latin America. I'm in this actually building on some work people have done in Argentina, in Mexico. So that dialogue, and maybe in Peru I don't see it that much in the historiography. I think I mentioned at some point, I see it more done in the scholarship on urban anthropology. But there is, I'm totally building on things here, perhaps adding a little bit more the legal aspect to this. So yeah, I think I can make that clear, and as you suggested, connected it better with the dialogue and what is being studied in the region. I think that's super helpful. And maybe one last thing that I will mention is that there is something here in relation to earlier periods, 19th century, the colonial period, in relation to other forms of corporations. Now that we were talking, now that we are going to talk about corporations, also about universities. For example, in the discussions that I have had with other historians, cofradías and other types of corporations, associations that are older have come up in the discussions. And actually, I am maybe, I don't know if this is the best way, but for the dissertation project, I'm not trying to go with it as a broad project, but I'm trying to take like drills in some things. So this I see it as a drill in the mid 20th century, and the other drill I will say, or the other case study that I am interested in studying is the final decades of the 19th century, and that's where cofradías, which is these religious organizations where people will organize around around some activities in relation to saints, in relation to virgins in the very Catholic world of Lima and other cities in Latin America. That's another way, another collective way of people organizing in a city that I am very interested, because it somehow contradicts what I see in the legal education around property law being a very individualistic type of law. I think in some sense similar to the US. And those contradictions, I see them in the 20th century and also in the 19th century, and it's very interesting that you just mentioned the cofradías as one example that came to your mind. So probably, as you mentioned, maybe as a mention here in the article, but that's part of perhaps the larger project in the dissertation. That's something that I'm very interested. I hope I can make those connections. So yeah, that's super helpful also to me. And there are others that I will just put a check that I will work on them, that maybe it's not useful for me to comment on them. But thank you so much for the comments and for the time in the reading. And happy to also other comments or clarifications on the piece. Sure. Yeah.
Thank you for the paper, Jose. Thank you for giving us the opportunity to read it. It was really fascinating to me. It's outside my all of my fields, except insofar as it's legal history. One thing I want to compliment you on right away is, and it sounds like a small thing, but it's about format. The fact that you open up with a narrative of a particular place, that you are grounding your reader early on. You're giving us context. And I think that sometimes when people write for academic journals, whether it's legal history or urban history or whatever. People forget about the importance of context and the importance of the narrative form to help establish context for the scholarship that you're engaging in. So I definitely appreciated the context and the fact that you gave us this narrative introduction that was helpful. And the comments that one comment really, and maybe in a way it relates back to something that Angie said. Angie talking about what was happening in other cities. I was struck by how you document the types of language, the practices and norms regarding language with these supposedly informal legal documents, in that they were not required by statute, but they came to be required by custom and norm. Specifically with regard to this case study of this one particular neighborhood, and I was thinking that even though it may be a fairly narrow case study, your purpose may be fairly narrow. It might help to show, and maybe I missed it, but it might help to show that other neighborhoods had similar practices. Mm-hmm. There were documents using similar types of language. There were similar norms with respect to other neighborhoods, so that this is a case study, but it also demonstrates that something more widespread was going on. Mm-hmm. And but I really enjoyed your paper very much. Thank you.
Thank you so much.
So I really don't know anything about Peru, so this might be a stupid question. But there are two parts to it. One, since you're talking about informality, and especially with neighborhood associations and getting adopted into the neighborhood, were benevolent societies or like landsman associations significant organizations in Lima for people from the provinces or people from other countries moving into Lima? Yes. And did this interact with the neighborhood associations in any way? And another thing, since you're talking about 1960 in particular, I know that in the 19th century, I'm thinking back to a Mexican history course I took, informal land claims pretty much meant nothing when Porfirio Diaz was divvying up land for railroads. Was there a similar dynamic in Lima in the 1960s? Because I know 1960s was a time of urban renewal in the United States with eminent domain and all that. I'm not sure if there's a similar thing going on in Lima.
Mm-hmm. Sure, yeah. Well, in relation to the first ones, to the first question, yeah, so there is I think it's even related to the second question. The 20th century, maybe especially in the 1940s, 1950s, and 1960s, but even until the 1980s, was a very strong process of migration from the countryside to the city. That's something that is happening around the world, but especially in Latin America. Latin America becomes very urbanized earlier than, for example, in Southeast Asia or in other regions that are the developing world, we could say. And it's a very specific type of urbanization, different than perhaps the US and Europe, in that it is not dragged by industrialization. It is just maybe a group of different factors which turns into informal settlements, informal neighborhoods that lack services. That's the process that is happening at this time. And that's why it is what you mentioned at the beginning. I think it's very interesting because benevolent societies or mutual aid societies, mutual aid associations, even again, and that's something that I'm not engaging in the article, but it keeps appearing. Catholic or religious institutions that give help as well are very much in this conversation, in these networks, in this environment. For example, in the case of in the case of Brazil, there are many mutual aid associations. There are workers' movements that are involved in the taking over of land. In Mexico, there is also, around the 1940s, 1950s, a similar phenomenon, but in the case of Mexico, having a very strong party, more state-led, but still with some phenomena that is a little similar to this in organizations of neighborhoods. So there is that happening. Specifically, the benevolent society, or the society of beneficencia is the name in Spanish. Maybe it will be an equivalent society of beneficence, and perhaps in English. In the case of Peru, it is more focused on the hospitals and some caretaking of children activities. But I think in general the environment does have this component. And again, that's I think interesting thing to explore, not only in Peru but in general in the region, because of that context of the migration to the city. And different to maybe the US, since you mentioned that specific period, I think it is not that much driven by infrastructure projects or something as it was here in the US in relation to the urban renewal project or the urban renewal years or decades. Because again, in this case, it was not that much driven by the state. It was just we could say a state ignoring that this is happening and maybe just putting a solution later, in that people are invading, people are squatting in spaces, they are organizing themselves, and the state is just not saying anything, and knowing that later the state will be giving titles as a means of also getting political and popular capital. That's the stance of the state. So it's not a very active state evicting people or moving people from other places. It's a more, we could say, organic movement that the state maybe later, and I'm going to use that term now, even though it's very debated in the article, is the state formalizing things afterwards, after the fact.
By accepting.
Mm-hmm.
It's
Yeah, and that's a phenomena that we will think not only in relation to land rights, but also in relation to many other things. Informality is something that people have studied in relation to street vendors, in relation to health services. So that's their, yeah.
This is going to turn into a question for Jose. I want to start from a much less specific level and try to make some relation between the two papers we've heard. In scholastic discussions of natural law, one can argue, I think, that there's an overlap between what we talk about as jurisprudence on the one hand and political theory on the other hand, for very good reasons. And one of the concepts in scholastic thought that's of political importance as well as religious importance is that of prudence. And a lot of the discussion about prudence is directed at rulers and people with power about situations in which they find themselves where they have an acknowledged legal right to exercise power. They can punish, they can kill, they can take property, they can do all sorts of things. But the scholastics say that's all fine, but there are circumstances in which it is unwise to do that. Now, frequently in political theory or historiography of the early modern period, these are described as reasons of state. We have to do this for reasons of state. It's an exercise of power. But in fact, as Aquinas and Vittoria and Suarez think of it, it's actually restraint, where you decide not to exercise power. And there are various ways to think about why this is happening. One of them, popular now, is that the authorities want to put on a display of mercy that they don't really care about. It's a cynical move to try to reconcile possibly rebellious persons who might be placated if they think you're merciful. But that, in my mind, is far too simple an explanation. It's actually a very important thing discussed as wisdom in natural law theology about why you might not exercise power. Because in part it's a recognition of the legitimacy of the minority, well, it's not even minority necessarily, but the groups without power position. Now, when we talk about imperial situations, or even state situations, some of this has to do, as legal historians of the early modern period think about it as recognition of customary law. We're going to let this particular, say from an imperial perspective, we're going to let this indigenous population continue to practice their customary law in this way and that way and the other way, because it isn't fundamentally violative maybe of natural law, or even if it is, it's not that severe a violation that it would justify the injury that we have to inflict on these people in order to carry out what is our legal right. And we should be wise and restrained and prudent and not do it, at least not now. We might do it later when we've had time to convince these people of how really right we are about how they should live. Yeah. You will recognize this as a Spanish colonial development. And it's now my question to you really is about, if this makes any sense to you, about the recognition of customary law. One thing I found really interesting about your paper, from my perspective, is this kind of recognition of what we might talk about as multiple legal systems and the legitimacy of another legal system, which isn't really best described probably as customary law. You describe it as informal legal system, but in a way it has certain earmarks of customary law, one could argue. And your focus, I found your explanation of the property issues incredibly clear, although I don't know anything about 1950s Peru either. And it's perfectly legitimately focused on the question of property law. But the question I want to ask you arises from what I just said before, and it is that when imperial or state actors with power of the kind I've described take this view that they're going to show some deference to customary law or informal law, there are usually certain areas in which they decide this is fine, family law being one of them, religious practices maybe being another. The one that they're least likely to defer to, in my experience in reading, is criminal law. Now sometimes they will actually allow, well, take the American colonial situation with which most of you are familiar. For a long time, in, say, 17th century Virginia, the English were more or less happy to allow the indigenous tribes in Virginia to have their own leaders who administer themselves and do whatever they wanted, as long as they didn't kill English people. But once they killed English people, then it was clear, even in the treaties they made, that now we would have to have English justice, or else the leaders of the indigenous people would have to agree to kill whoever it was that was singled out as responsible. And you can all think, of your knowledge of American history, North American history, how many examples of this are. So my question to you is, when the Peruvian state is showing this deference to community values and a communal notion of value and a certain kind of customary law in property, how far does this go in terms of other exercises of state power against the traditions and customs of the sorts of people who are in these settlements. Does that make sense?
Yes, very, very interesting. It's really interesting. It's actually something that I've seen people engage with in political science discussions. You've used the word prudence, the word restraint. For example, there is a professor at Harvard, Alicia Holland, a political scientist, that studied this phenomenon maybe in more recent decades, 1990s and 2000s. And the word she uses is forbearance as a mode of showing what is the stance of the state, of the government towards this phenomena. What I am not totally sure is how intentional or how deliberate is the state towards this. Whether this was very articulated as we do want to recognize community modes of acting in relation to land, in relation to their associations, or whether this was something that was happening and the change of governments, or perhaps a coup d'etat at some point changed the policy that they were going to implement, and that has been maybe a more an outcome that was not necessarily part of a very well thought policy. And I'm saying that I'm not sure about that. There are some certain evidences, certain laws, certain policies that show that that might have been part of the deliberate policy of the government at some points. For example, Peru is known because of the land titling programs, where Hernando de Soto, an economist, had a program of giving titles to land in informal settlements during the 1990s, a program that was later used in other developing countries. So that's something that I would like to explore. I think it's very interesting in that relation with the state, and how the state is having a position in relation to something that is happening in society in certain sectors. And again, I would like to do that comparison to other aspects. For example, criminal law as well. It would be very interesting how much there were dispute resolutions that didn't end up in courts. They were maybe solved in these spaces in relation to crimes as well. That will be very interesting. Now, something that I will also like to mention is that most of these arrangements and practices are within this network of associations and barriadas that I have shown. But some of these interactions eventually have to go to the courts. There are some snippets to that in the archives. When you go to court, you have to comply more with the civil code, with the procedural civil code as well. So that's why, coming back to your question, I'm not sure if the government is leaving some things for them, because when people have to go to the courts, to the official courts, people have to give official shape to whatever they've done in their own arrangements. These arrangements may be useful more when they are arguing against someone before the president of the association or before the federation of the associations, which is not small, but it's not the state in itself. So, yeah, but that framework that you've explained, it's very useful to think about this, even though you've framed it from a different geography and a different period. So it's very interesting. But yeah, thank you for the comment.
I'll just pick up one of the line that stood out to me most in your piece was this on page 15. You say, the window to legal practices of people in this neighborhood is the language they use in their documents. Not every word or phrase is a legal meaning. At least two elements give language a legal meaning: time and ritual. And I don't know why, maybe just like thinking about time and ritual together. I think this maybe, as I was thinking about my piece, thinking about common law, something about time and ritual together kind of has a very common law kind of flair to it. So maybe that's just why it picked up on me. This goes to the point about time and accepting practices. Two other observations. first is that I really like your reliance on the association records as an archival source. Even in some of my own work, I've found like professional association minutes, correspondence between people organizing meetings and all of that stuff as really interesting. It's a very interesting way, a very interesting type of source to use to understand the way that people who are making decisions are framing why they're doing certain things. So I thought that as a contribution to the historiography, I think the types of sources you're using are super valuable. And if this is for like an American journal or something like that, I think your selection of this type of archival evidence might be of broader interest, maybe than even is immediately evident in your piece. And then lastly, this is a part suggestion, maybe tangential to the piece that you've presented here, especially thinking about the religion piece, is that one of the great advantages, I guess serendipitously, of studying religious history is the amount of records and archival material that religious institutions kept, particularly Catholic, is volumes and volumes and volumes of information. So I wonder at all, this is more of something maybe you know, or maybe something to look into in the future, is I wonder if at all those religious associations that were related in this period and involved in Lima, if there's any archival material available there that might help give either an analogy to the associations that you're looking at, or perhaps they contradict the way that they operated, maybe contradicts the story you're telling here, and perhaps that's another project, but maybe just something to look into.
Yeah, thank you. Yeah, that second case study or second reel that I mentioned in the 19th century, in the last decades of the 19th century, with these other types of association that have a religious component, the cofradías. In that one, the main archive is a religious archive. The Archbishop archive in Lima, also some other religious archives. So that's totally there, and I think that's also something very nice to explore. What the religious archives might have also of this period in the 20th century of some activities in those areas. That's something that I hadn't explored. So I think that's something to look at. So yeah, thank you for those comments. That's something to check more. Yeah.
Hi, I'm Justin Brooks. I'm a PhD student at Harvard. Got my JD from Berkeley Law. I'm interested in the section on the ambiguities in legal practices. I wanted to know if you could speak more to the story of contract law in this. And you kind of make a critique that, or not a critique, maybe just a showing that contracts were legally insignificant, right? They had no sort of legal bases, or it didn't actually protect people's possession or anything. It wasn't necessary. Could you speak more to maybe some of the reasons as to why contract was used as a form of protecting someone's possessory right?
Right. So maybe I wouldn't say that they were not useful in protecting their rights, because maybe that's the conclusion that I will have as I could say a law student reading and studying the civil code, the contract law section of the civil code in Peru, reading the doctrine, and then turning and seeing these contracts not complying with many of these things that I see in the formal law, and that's the breach that I'm finding there from the perspective of traditional legal analysis of these things. But what I will say is that interestingly, if you see this in a more historical type of study or more social history type of study, you see them having use and validity and even better effectiveness, perhaps, when you see them in their context and see them in a not in their maybe formal value, but in their substantive value, in that perhaps that contract of transfer of possession, you take it to the court, and that will be considered something that very easily be discarded in a court, and also perhaps in a law school. But if you take that to the discussions, the dialogues within the association, or in the discussion between this association and the other association, they are applicable, they are complied with, and they can even be a source for, in the case of a dispute, a source for the resolution in favor of one party or another. And what my critique there is that all these interactions, sometimes we are labeling with this word of informality, and that's actually the norm. That's actually the majority in Peru. For example, there is this figure that is used in Peru that around 90% of the neighborhoods of the created in the last 30 years in Peru are informal. That's a figure that is used. So if 90% of the neighborhoods in Peru are being created in that informal way, should we just label them as informal and there's a blank space or a dark space where law is not being applied? Or what tools we have to analyze the law that is happening there? That was my take on there. So I don't know if that maybe didn't come through like that in the article, and that's something I would like to check. But that's my take on there. But I wouldn't like to separate that much that informal law or that customary law from the official law, because I see them interacting a lot. So they do maybe do some mentions to the Constitution or the Civil Code at some point, but maybe they depart in some things like the use of certain formulas or the use of certain arguments like having children or being a Peruvian. So I see them interacting a little more.
So maybe a helpful term could be quasi-legal?
Perhaps, yeah, perhaps.
Quasi-contract. Can I jump in? I know we're starting to
it's okay.
run over. Hi, Justin. I have a JD from Berkeley Law as well. But not too many of us on this side of the country.
Come to the history department.
Jose, thank you. I learned so much from the piece, and I really appreciated, as many others have said, the way that you excavated that archive and brought some unfamiliar concepts and procedures to light. And my comments are mostly because I'm greedy. I want more, and I want more partly in my hat as somebody who teaches property law in the U.S. context. Because when I read your title and that first paragraph in which you sort of referenced the that sharp dispute that came up between the association and the original owners of land, I expected that to be the heart of the piece, and I kept reading for that, and I'm like, where is that? Where is that dispute? Where am I going to see that moment? And I don't know if you want to go there, and I thought it was very interesting when you wrote your summary of what you learned from the piece, and you're like, yeah, that's right. You didn't use the word property at all.
No.
And so I'm like, aha, there's two.
But I have questions.
So there's two different things going on here, and so these may be, my greediness and my interest may be peculiar to me and not where you're wanting to go, but to the extent that you do, I really wanted to know the history of the ownership from the colonial period into that moment. So who's owned that land, who's been living there, where these people have come from. They're mentioned as immigrants, right? You mentioned this, the ethnic differences, what ethnic differences are involved there. That there's so much more you could do us in terms of before this moment, and then, as I said, I'm greedy. I would really like to know about those moments in which the association spoke to ownership and more about the words that they used. I'd also like to know more about what you just told Justin, the moments in which people used those material documents, those words that they wanted to have effect in the world in the association to have effect in terms of, I'm assuming, excluding maybe somebody else in the association who's claiming the same thing, even though they couldn't use those rights to exclude in the courts. I would like to know more about that. And then I'd like to know more about the after. You said some intriguing things about, well, the state just sits around and waits, and then eventually the state can get political capital by perhaps formalizing what's happening on the ground. And I'd like to know more about the after. I was also really struck with what you said about when the imperial state will and will not defer to customary law, because when you said the one time they won't do that is the criminal law, and I thought, yes, your examples are right, but I was expecting you to say the one time they won't do that is with respect to property law, right? That property rights is a way of the imperial state extracting value, and in a settler colonial state, settling, and that's the number one thing that the U.S. court, does very early in U.S. history, is Indian title is a separate thing that we are not going to consider, right? So I was interested in that question of when you're illuminating that question, when do you defer or not defer to other laws of property ownership? And to the extent that you want to make this piece cognizable to me, which I'm not sure that you want to do, or to U.S.-centered readers of depending on where you're publishing this. I kept thinking of Robert Ellickson's book, Order Without Law, right? How neighbors settle disputes. You can make definitely the contrast between, as you said, having 70-90% of the neighborhoods in Peru and other Latin American cities being informal. You can heighten that contrast. You can also diminish the importance of that contract. This is not some sort of quirky Latin American thing. People have informal laws, particularly with respect to property and property boundaries in all sorts of situations, including in the contemporary United States. And you could go in that direction with it. And deferring completely to you and your expertise in this area, I was also thinking about sort of the historiography of borderlands, that this is, you described, a borderland between the city, between the country, I think between perhaps different ethnic backgrounds of people, different relationships to the colonial state, and I wondered if some of that historiography might be useful too, to open up the historiography of law in borderlands, right, and the fact that they're always contested in that space. So thank you very much.
Thank you. Thank you so much.
Can I piggyback?
Yeah.
To finish, because I'm glad the conversation went all around and landed on property and land. To me, so you made the distinction about possession and property that I find in 19th century Chilean documents as a way to argue, I have possession of this land, I have had possession of this land, as I have been living here informally because the state didn't exist here, essentially, for 15 years, therefore I deserve a land title. So, informality anteceding formality in some ways. So I had a question of how you're reading possession, if that reading of possession is your take, or is this something that you are tapping on other studies? Because sometimes possession is, is a historical, I find it like more of a historical word than that I wouldn't talk about possession in that way.
Right.
We would talk about property. And you're basing, so going back to these questions, the legal central point is that code of 1936, correct? Which is not the first time that Peru legalized or created a code on property. After independence, in general in Latin America, there was a transition between the legal framework for indigenous community that existed in the colonial state to a kind of incorporation of indigenous communities as citizens of the state, and therefore having to abide to property law. And in 19th century Latin America, liberal states created private property to create public property, right? Like delineated where the estates were, so that the rest was the state. And that essentially evicted people from communal lands. But here, the creation of private property is to kind of resist what in the 19th century have been the advances of capitalism and extractive economies. Here is kind of, at the skirts of, the outskirts of Lima and of productive states. So kind of also encroaching those private lands to create a kind of communal sense of shared space. So I don't know, these are the multiple layers, and I think that you have to talk about that code more and the history of coding property and possession in Peru, because I think it's going to really illuminate this case study and make it like very clear for the rest of us how important it is to
Yeah,
communicate
yeah,
this to the
totally.
world.
Thank you. Yeah. Yeah.
Before we wrap up, I know we have at least one person actually zooming in from a partner university in South America right now, so I don't know if anyone on Zoom had any questions or comments that they wanted to share.
No, but thank you for the presentation.
Thank you, Mike.
Hi.
Hi, we can hear you, yes.
Hi everyone. My name is Macarena. I'm a law graduate from the Alberto Hurtado University. Perdonen mi inglés. Forgive my English. It's very poor. And I appreciate the opportunity and being present here. I think that the topic present by Professor Fernandez is a very interesting topic, since the urban regulation of city is closely linked to the history of the territory itself and how it was founded. Históricamente, historically, Lima has been an important city for South America, especially for countries like Argentina and Chile. The foregoing added to political context of the second half of 20th century, where forms such as the acquisitions of property through cooperatives arise, which, as Professor Fernandez mentioned, is something like linked to the social doctrine of the Catholic Church. Está muy vinculado el cooperativismo con la propiedad, con el tema de la doctrina social de la Iglesia, por lo menos acá en Chile, in the sense of the beneficencia among those who live in close proximity, and because property acquisition remains a problem till today. And creo que es un gran tema, de verdad. Nunca, acá en Chile, por lo menos la historia legal que se estudia, no hay un estudio de la regulación histórica que ha habido en la ciudad. Entonces, muchas gracias.
Thank you so much.
Thank you for joining us as well. I'm glad you were able to make it.
Right.
Thank you for having me. Please forgive my English.
No, totally fine. Totally fine.
We have a Boston-Area History Colloquium on 2 continents, 2 languages, 2 coasts. What's next? Well, we'll wrap up there. We'll go to lunch, and then we'll be back right before 1 for Mike's presentation. And I know Professor Melnick will join us around then as well. But thank you again, Jose, for sharing your papers.
Thank you so much. Thank you everybody for the comments.
And lunch is behind you guys as usual. Feel free to take it if you'd like.
I mean, we could have put
yeah.
Macarena with the closed caption, like subtitles or translation. You know how there are live translations.
Yeah,
and-
Won't work,
yeah.
I don't think. Judging from my-
Really?
Trying to use closed captions for this, I don't know if you hear.
Thank you so much for the comments.
Yeah, of course.